Morning, my name is Dan Murphy. I'm a lawyer out of Edmonton, Alberta. I just wanted to discuss how at MD Law we prepare you for trial. Trial is essentially the final juncture in proceedings outside of an appeal. This is usually after negotiations with the prosecution have not gone as we want, or they simply wouldn't negotiate, and trial was our only option. In terms of preparation for trial, the process begins early. We receive disclosure usually after your first or second appearance. If it's a larger file, it may take some more appearances. And then we review that disclosure ourselves first, and then with you as the client. Now, as a client, it may very well be that I don't need much from you by way of an explanation or a narrative, or alternatively, I may need a narrative. I often tell my clients to write the narrative down for me so it has a sequential order, because when we tend to tell stories, we do A, D, G, Z, and then back again. So what the writing exercise does is force us to enter into a narrative A, B, C, D, so it's linear and the story makes sense, because we have to remember the trial judge, when they're sitting on their bench, they don't have the benefit of statements. They don't have benefits of evidence. We're presenting that evidence to them. So that's the reason it's critically important that no details are missed when testimony is given. We also run our clients through a mock trial, and especially with bigger files, where we engage in some direct examination. Maybe not related to the case, but definitely just to give them a flavor for how those type of questions are asked, as they are different than cross-examination. And then they undergo a cross-examination. A cross-examination is unique in the fact that people are not used to answering questions this way, and it's necessary in order to get people prepared for what the prosecutor will ask them. Trial itself doesn't look dissimilar from television. You have a judge above sitting on the bench, and then you have the defense lawyer and the client, and then the prosecutor, okay? Prosecutors usually on their own, but sometimes in larger cases there's two. And what happens is the prosecutor is responsible. It's their burden to prove the case beyond a reasonable doubt. You're presumed innocent. So the prosecutor calls their case. They call their evidence. We get an opportunity as defense to challenge that evidence, and then ultimately we decide whether we're going to call evidence. Now, this is a decision that we'll make long before trial. It's a critical decision. Testifying can either very much help you, or it can sink you, depending on the type of case. Again, a lawyer with experience will be able to guide you as to what's appropriate in your circumstances, but ultimately you must remember you're the boss. The lawyer works for you, so you've got to be comfortable with the instructions you give, and be willing to tell your lawyer what your instructions are, and ensure that they honor those instructions. In terms of the remainder, trial the day of, make sure you're not dressed in crooks and castles or cocaine and caviar. Dress in the proper outfit as you have. You don't have to be in a suit, but something nice, and sit quietly with your lawyer. Bring a notepad, take notes, pass the notes to the lawyer. The most difficult thing is when clients start talking to the lawyer as he's trying to listen, or she's trying to listen. This doesn't help, so it's best if you write notes for your lawyer to follow up with, okay? So that's what I would suggest. I think beyond that, it's just knowing the details of your story. If you're telling the truth, you'll never have a problem. It's when you get into lying that you have difficulties. And so I suggest that as long as you're telling the truth and you're willing to take the stand and tell that truth, you should be more than fine. Okay? Thank you. Goodbye.